Hello everybody, welcome to this match for the third place of the Hague Inter-University Law Debate Tournament 2022, organized by the Corax Foundation from The Hague here. My name is Aurélien Orange, and with my colleague Miss Urbanova, we'll be hosting this match, which is with two teams which qualified to the semi-finals and now are having their match for the third place. So we'll have the team from Dom Helder Law School in Brazil, from Belo Horizonte, and we'll have as well the University of Colombo in Sri Lanka, so in the city of Colombo. So together we will be having this match in few minutes, but of course first we'll have the introduction of each participant to this match. They received of course the topic 10 days ago, but now we'll hear about them on this topic. So now I would like to give the floor to Mr. Lafuente Peña. Could you introduce yourself?
Thank you very much, Mr. Lavange. My name is Fabrício Lafuente Pena. I'm a fourth-year student at Dom Helder Law School in Belo Horizonte, and it's a pleasure to meet you and debate you guys.
Thank you very much. Miss Tarushi Kamage.
Hello everyone, I'm currently a final year undergraduate at the Faculty of Law, representing University of Colombo from Sri Lanka. Thank you.
Thank you very much. Mr. Lucas Tavanias Murta de Sousa.
Thank you very much. I am a fourth-year law student in Dom Helder Law School in Brazil. Thank you.
Thank you very much. And Miss Medmotu Abewikrama. Yeah, you are mute, Miss. Yeah.
Good evening, everyone. Good evening, everyone. I'm Medmotu Abewikrama, a final year undergraduate from the Faculty of Law, University of Colombo, representing Sri Lanka. Thank you.
Thank you very much. And we have as well the presence of one of the coach, Professor Bastianetto. Welcome.
Thank you very much, Professor Lahange, and the best of luck to you all.
Thank you. So the topic that both teams received more than 10 days ago actually was the use of the non-fungible tokens, so NFT, should be encouraged by legislators as a way to enforce the protection of intellectual property rights in the virtual domain. So both teams have prepared for 10 days and they will know which position they will have, either in favor, either against. So as you can see, there are two possibilities for each team. So now my colleague will click in order to know which position they will get for the match. So Dom Helder Law School will be against that motion, so as a consequence the University of Colombo will be in favor and will be starting the match with opening statement. So to clarify, the University of Colombo will defend the position that the use of NFTs, so non-fungible tokens, should be encouraged by legislators as a way to enforce the protection of IP rights in the virtual domain, while the Dom Helder Law School team will be defending the position that the use of NFTs should not be encouraged by the legislator as a way to enforce the protection of IP rights in the virtual domain. So now both teams have 5 minutes to review their arguments, and after we'll start with the University of Colombo. Here we are done with the time of the preparation, so we'll start the match. So the University of Colombo will be in favor, so this is the reason why we'll give the floor now for the opening statement to the team of the University of Colombo. You have 4 minutes.
Before I begin, may I confirm that I'm clearly audible and visible?
Yes, you are.
Yes.
Thank you. Good evening, dear judges and my opponent team. The protection of knowledge and ideas through respecting intellectual property rights has become a major issue worldwide. Prospecting that intellectual property rights should be respected with the development of new technologies, I'm Mekmutwa Bebikrama, presenting the debate with my colleague Tarsh Gamage. We will be arguing for the statement that the use of non-fungible tokens should be encouraged by legislators as a way to enforce the protection of intellectual property rights in the virtual domain. By setting the parameters of the debate, we see that non-fungible tokens, or NFTs, are a type of digital assets that are unique and cannot be replaced and authenticates asset ownership using blockchain technology. As problems in the status quo, we see that intellectual property in the virtual domain can be easily copied and pirated, causing serious financial losses. Other wider issues, such as the territoriality of trademarks and cyber spotting has made the detection of intellectual property rights infringements in the virtual domain a complex task. Therefore, we observe a trend in protecting these rights through the encouragement of NFTs. Why should legislators encourage the use of NFTs? The arguments shall now follow. Firstly, we see that NFTs strengthen intellectual property rights because each NFT is stored on a blockchain and assigned a unique identifier. It is impossible to create a duplicate. Most NFTs include a license that only grants the NFT buyer the license to use, copy, and display the NFT. NFTs can be used to transfer ownership of patents since the blockchain can be used to create records of patent owners. And the tokens can have self-executing contracts that transfer the legal rights associated with patents. Therefore, NFTs strengthen copyrights, trademark rights, and patent rights. For example, as per Article 5 of the World Intellectual Property Organization's Copyright Treaty, compilations of data or databases are also protected as copyrighted intellectual property. As pragmatic examples, Jack Dorsey sold an NFT of his first ever tweet, yet he still owned the copyright. Thus, the owner of the NFT could not sell or print the tweets without Dorsey's permission. Also, members of the Bored Ape Yacht Club have commercial usage rights to their apes, which means that they retain the right to sell their products. Secondly, we say that NFTs cannot be counterfeited like traditional assets. NFTs cannot be counterfeited because they cannot be duplicated, and the original digital copies could be distinguished from subsequent copies. Thus, companies have adopted this trend to fight against counterfeiting. For example, the renowned brand Nike is headed in this direction. When a buyer purchases a physical pair of shoes, they will also receive an NFT linked to the pair of shoes. Nike and buyers then use the NFT to confirm authenticity of physical shoes and whether it passed through a valid chain of title that began with Nike. Thirdly, we propose since NFTs give benefits for the real owner. Unless there is an assignment of copyright with the NFT, the copyright generally remains with the owner. Any royalties that may come from the work later will belong to the owner of the copyright regardless of who owns the NFT. NFT creators can also choose to add a royalty rate during the minting process with royalty specifications added to the smart contract. Moreover, NFT royalties can give creators compensation each time their NFT is sold. This option presents a new way for artists to continue monetizing their work beyond the initial sale with lingering intellectual property rights. Therefore, for the mentioned reasons, we proudly propose this motion. Thank you.
Thank you very much. So now we will give the floor to the team of Dom Elder Law School as well for the opening statement. You have 4 minutes.
Thank you. First of all, am I audible and visible?
Yes, you are.
Small.
Thank you. Honorable judges and estimated counterparts, greetings. Non-fungible tokens, also known as NFTs, is a new prominent technology that has attracted the public eye recently and became the topic of many discussions due to its high commercial value and innovation on the market of digital art. Firstly, it is important to clarify the concept of a token. It can be defined as a digital unit of value that represents a digital asset. A non-fungible token, in turn, is a unique digital asset created by a process called minting, where this specific token has an exclusive value and cannot be replaced or substituted by any other asset. Anything that can be digitized can be turned into an NFT. So for instance, pictures, drawings, paintings, or videos all have the potential to become an NFT. It is indeed a great mechanism to create added value, and its trade has become increasingly common amongst the digital literate. But from the perspective of intellectual property rights, it is still an incipient and flawed technology that does not reach the objective to fully protect those rights. Thus, its use cannot be encouraged by legislators. We defend this position mainly because it is ineffective, it was not created for this purpose, and the assets are still subjected to plagiarism and piracy. Initially, NFTs wouldn't be the best option to protect intellectual property rights in the virtual domain because by definition they are nothing but a metadata encoded file that uses a work or production that may not be subject to copyright protection. It could even be a physical art piece. As an example, some pieces in public domain from the Rijksmuseum in Amsterdam have already been turned into NFTs. There is an increasing confusion amongst the mainstream press when reporting on the sale of NFTs, because people often assume that it is the work itself that has been sold, when in reality, buyers are spending colossal amounts of money on what amounts to a metadata file and a short string of numbers and letters of dubious artistic value. For that reason, NFTs have very little to do with intellectual property rights. Moreover, there is the potential issue of intellectual property rights and copyright infringements, as it is easily possible to generate an NFT that doesn't belong to the person. This means that anyone can make erroneous ownership claims and register them into the blockchain. And that would create an even bigger problem, because it would increase the burden of the actual creator to prove that the asset is their own creation. In addition, as the NFT is not the work itself, but a string of numbers that have been generated in relation to a work, the resulting file could not be considered a legal reproduction, but a mere copy, especially when minted by another person without the permission of the creator. Thus, the NFT is not able to fulfill the legal demands related to intellectual property rights. It improves the protection when the own author creates the NFT, but it cannot avoid ongoing problems like piracy or plagiarism. The certificate of ownership of the asset created by the NFT has an intrinsic value, but the creator of the artwork, when selling the NFT, for example, cannot ensure that the art will not be printed and exposed in a public space, for example. If something like this happens, he will not have the right to receive any compensation for the exhibition of his work. The author will only receive the royalties related to the trade of the digital art and the possibility to trace the NFT in the blockchain, but nothing else. In conclusion, based on the blatant facts, we defend that the use of the NFTs is not capable of protecting intellectual property rights of the authors when in the virtual domain, thus it should not be encouraged by legislators. There is still a long way to go in terms of regulation and technology development for NFTs to become an effective mechanism for the protection of rights. Thank you.
Thank you very much. So now we'll start with the first rebuttals. So I would like to give the floor to the University of Colombo for the first rebuttal. You have 2 minutes.
Before I begin, may I confirm that I'm both audible and visible?
Yes, you are.
Honorable judges, two main points to be addressed in this debate. Firstly, it is argued by the opposition that one of the major reasons that they stand against this motion is the ineffective and impracticality revolving around the non-fungible tokens. However, members of the panel, we can see how several countries in the world are in the process of reshaping their regulatory schemes in order to give validity to NFTs, because they can be seen as an effective way of protecting intellectual property rights in the virtual domain. For an example, in France, the French Parliament has already discussed the possibility of excluding NFTs from the fiscal treatments usually applicable to other kinds of digital assets and to define an ad hoc tax regime for non-fungible tokens. Similar attempts can be seen in other countries such as Norway, Switzerland, and Germany. In Norway, cryptocurrencies are legal, and Switzerland is also known as one of the most cryptocurrency-friendly nations in the world. Furthermore, the German government also is one of the first countries to provide legal certainty to financial institutions, allowing them to hold crypto assets. Therefore, it is evident that it is not ineffective or impractical, because several countries in the world are already adapting these procedures through validating cryptocurrencies, which are important to NFT. Secondly, it is argued by the opposition that there can be copyright infringements. But members of the panel, it has to be understood that these NFTs are not going to function in a vacuum. Therefore, there are certainly existing laws and regulations that would prevent these infringements. For an example, the United States has the Copyright Act of 1976 to prevent these types of crime. For these reasons, we strongly propose this motion. Thank you.
Thank you very much. So now we'll give the floor to the team of Dumbledore Law School as well for the first rebuttal. You have 2 minutes.
Well, am I audible and visible?
Yes.
As much as we understand the points presented, we must disagree. Although well-intended, our counterparts underestimate the potential risk of an inefficient intellectual regulation over digital certificates. A general regulation of NFTs will not serve to its purpose of preventing someone to steal a new art or achievement and register it with an exclusive token, as well as earn money through this fraud, mainly because NFTs were not designed with this intention. In this case, even though an artist has unequivocally proven the property over ownership and copyright on the blockchain, the mechanisms to claim ownership are the classical ones, such as filing a suit in the real world in real courts. In this sense, NFTs must be regulated for other purpose than IP protection. Once there is no possibility of dispute settlements inside the blockchain. Not to mention that, as outlined previously, digital certificates do not provide any protections to physical copies, as they are utterly separated from their token. Moreover, it is good to remember that smart contracts are very limited in terms of clauses, causing a shortage in protection regarding ownership and serving only for financial compensation of transactions on the web. Thus, although intended to revolutionize security and disrupt bureaucracy, it may well need the traditional and everlasting solution of classical dispute mechanisms. Thank you.
Thank you very much. So now we move to the second round of our battles. So I would like to give the floor to the University of Colombo. You have 2 minutes.
Before I begin, can I confirm whether I'm clearly audible and visible?
Yes, you are.
Thank you. Honorable judges, before I proceed with my substantive argument, one major point to be addressed in this debate. It is argued by the opposition that these particular NFTs cannot be used to promote the intellectual property rights because it was intention not created for this purpose. But members of the panel, even though it wasn't created for this purpose at the first place, we still can use the same technology for the benefit of the intellectual property rights in the virtual domain. As it was reiterated by the opposition first speaker, which they referred NFTs as something which cannot be replaced or sustained, it is clear that these NFTs cannot be duplicated itself. Because of this unique character attached to these NFTs, we can use this same technology to protect the intellectual property rights of the NFTs owners. Furthermore, panel, it must be made clear that as the proposition, what we advocate through this motion is not to encourage the use of NFTs for any commercial purposes where people can be scammed, but only these NFTs should be encouraged for the effective protection of intellectual property rights in the virtual domain considering its unique characteristics. Furthermore, moving on to my substantive argument, there is a specific example which we can say that these particular NFTs are giving you the royalty fees. So because of these reasons, we are clearly proposing this motion. For an example, the Daniel de Bourcy, CEO of technology firm, have explained to media that the smart contracts can be used to empower artists to distribute royalties in an effective way. For these reasons, we strongly propose. Thank you.
Thank you very much. So now we move as well we give the floor to the team of Domelder Law School, as well for the second battle. You have 2 minutes.
Okay, am I audible and visible?
Yes, you are.
Thank you. We thank our counterparts' considerations, but we beg to differ. As already stated before, we are talking about the unicity of the token, not the artwork. NFTs are not capable of protecting intellectual property rights because the picture or any other digital asset in question can be easily accessed, copied, and displayed by anyone. What the NFT does is create scarcity and add value to the assets, transforming the NFT in the original and the others into mere copies. An emblematic case involving famous model Emily Ratajkowski serves as an example here, where artist Richard Prince used one of the model's Instagram pictures without her consent and turned it into a canvas, which was sold for the equivalent of $80,000. Emily, as a person that makes a living out of her own image, did not receive a single dollar for the sale of the canvas. She understood that in the context in which she's inserted, her reflection is never home. Hence, as she stated, in order to regain control of her image, she created an NFT of a picture of her in front of the same canvas and auctioned it at Christie's, the most famous auction house in the world, for the equivalent of $175,000. That way she could earn the profits gained out of her own image, but unfortunately, as the NFTs do not have such capacity, she could not control the intellectual property rights derived from it. Another important question to be raised to our counterparts is, if most NFTs are being sold using cryptocurrency and not national currencies, in case legislators encourage this type of digital trade, how are the traditional national economies going to cope with the imminent downfall of their currencies? The popularization of the NFT commerce does not have any geographic or monetary limitations. So how can it become something positive for the internal market? Thank you.
Thank you very much. So now we move to the conclusions. So we would like to hear now the conclusion on the side of the University of Colombo. You have 2 minutes.
Begin, may I confirm that I'm clearly audible and visible?
Yes, now you are visible and audible. Yeah.
Thank you. Honorable judges, this debate has boiled down to a major question. It is on whether the primary purpose of this debate, which is protecting intellectual property rights in the virtual domain, is achieved through the encouragement of NFTs. Along those lines, I will now conclude as to why we propose. We emphasize the inherent nature of NFTs. They are unique and cannot be duplicated, which is why we encourage the use of NFTs in the virtual domain. Firstly, we argued that the NFTs protect intellectual property rights on trademarks, patents, and copyrights due to the non-duplicable nature of the NFTs. We further argued that they protect these intellectual property rights in a more expeditious manner compared with that of physical assets. We supplemented our arguments by bringing world-renowned examples. Secondly, we argued that NFTs cannot be counterfeited like traditional physical assets. Thirdly, our proposal promotes the intellectual property rights of real owners of the asset, since royalties are provided for the owners of the original copyright. My colleague further pointed out the trends adopted by countries in legislating NFTs and cryptocurrencies. However, the opposition opposed, saying that NFTs could be ineffective and plagiarized, and they might cause erroneous ownerships. These arguments were sufficiently rebutted by us by giving practical examples from jurisdictions, and the opposition did not sufficiently prove on why NFTs are not protecting the intellectual property rights in the virtual domain. Therefore, members of the panel, it is quite evident as to why our proposal caters solutions to the issues of the present status quo. Therefore, for those reasons, we propose the motion. Thank you.
Thank you very much. Now we hear the conclusion as well from the team of Dom Elder Law School. You have 2 minutes.
Audible and visible?
Yes, you are. Yeah.
Hence, Excellencies, we shall reassert our disbelief in the protection for intellectual property provided by NFTs. Firstly, as of today, although blockchain technology is meant to be a decentralized network, NFTs do not intend to create better safeguards to protect intellectual property for the peoples. The first step that should be carried out by states is to inform the population about the actual objectives of NFTs, which is to create scarcity and facilitate payments without intermediaries such as banks. Besides, we should consider that the majority of the peoples are not literate to benefit from this technology, allowing a select elite to use it against minorities excluded even from the internet itself. On the other hand, smart contracts have considerable limitations, which impedes them to enact intellectual shields. Thus, despite the possibility to store information of any goods in the blockchain, the digital certificate does not avoid infringements in the physical world. Therefore, the hope to solve the complex problems of copyright and ownership violation through smart contracts is unrealistic. Thus, there is the need to resort to the classical dispute settlement systems. Finally, whether any transition is intended, it must watch the obligations provided by human rights, the democratic participation of the peoples, and the current framework of intellectual property protection, which is still not an objective of a NFT. Thank you.
Thank you very much. So now we are done with the match, with the debate. So from now you are not anymore under evaluation. So of course, as usual, we'll ask you for your impression. This is the last match for both teams for this competition for edition 2022. And of course, afterwards we'll finish concluding what will be the next step, obviously, from the side of the organization. So first of all, I would like to give the floor to Mr. Lafuente Peña. So what did you think about this match, your performance, the performance of the team, the other team, and in general, the whole competition?
Thank you, Monsieur Laurent. It was a pleasure for me. I think this is a very dear topic for me because it's something I'm very interested in. And it was a pleasure to debate against our counterparts from Sri Lanka and meet you guys. And also a pleasure to learn more about international law during the whole debate. Thank you very much.
Thank you very much. So now, Miss Tarushi Gamage, what did you think about this match, the whole competition?
I also think that this was quite a passionate debate between we and the team from Brazil. And also, I must say that this particular motion was quite unfamiliar to both of us, me and my colleague, but we managed to do a proper research before coming to the debate, and I think it was quite important for both of us to improve our knowledge on these kind of new areas. Thank you.
Thank you very much. Mr. Lucas Tabanias Murta de Sousa.
I think, first of all, I should thank the organizer for this amazing competition, this amazing theme that we've been through. And this specifically was very interesting for me as I was unfamiliar, such as my colleagues from the Sri Lanka. And I want to thank you for the amazing effort you put to present such a great argument in this debate. Thank you very much.
Thank you very much. And Miss Menmutu Abewikrama.
Actually, it was a really great debate, and our opponent team brought up with really good arguments, and it was a really novel area for us to research upon, and we definitely improved our knowledge on this specific area. And we are really glad that we could make to the final day of the tournament as well. Thank you very much once again for the Corax Foundation, and I wish good luck for everyone. Thank you.
Thank you very much. So now I would like as well to give the floor maybe to Professor Bastianetto, who is still here. Yes?
Yes, I'm still here. I'd like to congratulate you, Professor Laurent, for the organization, and also Ms. Urbanova. I know it was quite a challenge to control and organize with such brilliance, such a long competition and with a worldwide participation. So it's quite a complex challenge, and thank you for that. Thank you for having this organization so brilliant during the whole competition. I'd like to thank as well my delegation for their their efforts. It was brilliant, and it was very important this time we had, this close time we had in trainings, and also congratulate the 2 oralists from Sri Lanka. It's a pleasure to meet you, to get to know, to be alive with you remotely. Thank you very much, and congratulations for your brilliant presentation. I hope we can meet one day in presence, either in Brazil or in Sri Lanka. Thank you very much, Professor Lohange. Thank you all, and the best luck.
Thank you very much. So now on the side of us organizers, of course, everything we did during the whole competition was to give visibility to the students, to the talented students and teams, and it would have not been possible without the support as well of our sponsors. So the sponsors that we got for this edition, which was the Oxford University Press, who helped us as well on getting ideas as well on the topics and on other aspects. And of course, Absolute Internship, which is a company which as well helps students on placing themselves in internships around the world. So both sponsors were extremely helpful for this edition, and of course we thank them for the trust for this edition, which had indeed for the first time 32 universities around the world from all the continents. So we want to thank, of course, during this match, the 2 teams which are present. So the team from Brazil, from Sri Lanka. The Brazilian team, of course, did very well again. It's not the first time they participate, but always excellent, of course, performance. And for the team of Sri Lanka, for the first time participating as well, it was excellent to see that you arrive among the 4 last teams of the competition. So it means obviously on our side as organizers that we hope that next year both schools, both universities will be presenting as well a team for competing in 2023. And of course on our side we'll be looking for additional teams possibly to participate. But in any case, many thanks as well indeed for participating to this such a long competition of 4 months. And yes, so now I would like to give the floor to my colleague.
Thank you very much to my colleague Ms. Lohange. Thank you very much to the teams from University of Colombo, Sri Lanka, and the team from Dom Helder Law School from Brazil. Well done on getting this far. It's been a long journey, and we have seen your students and your debates improve from day one. It's been an honor, and we look forward to announcing the result. On that note, please allow me, on the behalf of the organizing team, to invite you to the closing ceremony. We'll announce when it takes place as soon as we start receiving the first results from our honorable judges for this final round. Both the ranking positions will be announced, as well as the awards for the most watched debate team, and you will also have the option to vote for the most favorite debate match of the second phase of the competition. So keep an eye out for that email. You might have already received the first link for the first 2 rounds of the second phase, so don't hesitate to share it with your faculty and friends. And on that note, once more, it's been an honor and a pleasure to watch you progress throughout the competition. We look forward to seeing you at the closing ceremony, and hopefully in the next year as well.
Yes, so many thanks in Sri Lanka, many thanks in Brazil. You did great during this very long competition compared to other competitions, you know. So indeed, so since March, we have a match with all the teams. So we are very happy to close with this last match for your both teams. A bit later, there will be the match between a Dutch team and a Canadian team for the final, so you can watch it as well. But yes, please share the message to other students in your faculty that next year we hope to have as well a team from your schools, and in order to compete with indeed all these other universities around the world. And as well with new topics and new themes next year, as usual, because we create them in winter time, let's say, European, I would say, region. So yes, so many thanks again, and we'll inform you as soon as we have the results, and then yes, you get the invitation to hear the results live. So thanks again, and I wish you a good rest of the day in both regions of the world, and we keep in touch for the next and last step of this competition. Thank you again. Bye-bye.
Thank you. Bye-bye.
Bye-bye. Have a nice day.
Bye.